Let's first look at South Central Timber Development v. Wanakee, a 1984 case that describes the development of the market participant exception and its limits. At first blush, Wanakee seems to involve another impermissible local processing requirement. The commodity in question is timber. Alaska required that timber purchased from the state be processed, that is, turned into construction lumber, paper pulp, or the like, only in facilities located in Alaska. The difference from other local processing requirements was that the state itself was a participant in the market. It was state-owned timber harvested from state lands. As Justice White's plurality opinion notes, the court had held that the Dormant Commerce Clause involves the state's ability to regulate interstate commerce among private actors, not the state's ability to set conditions on commerce in which the state itself engages as a participant in the market. The distinction drawn was between the state as market regulator and the state as market participant. To get your head around this, imagine a contract between a private landowner and a logging company for the right to harvest timber on the private land. Could the landowner include a provision in the contract requiring the logging company to process the timber in a particular facility or in a facility located in a particular geographic area? Such a clause in a private contract would not implicate the Commerce Clause at all. The Commerce Clause involves the ability of the government and the state governments to regulate commerce. A contract between private parties with this kind of clause might be difficult to enforce, or might in some relatively rare circumstances run afoul of antitrust laws, but it would not otherwise be unlawful. After all, if the logging company doesn't like the terms being offered, it can seek to purchase timber rights elsewhere, or it can bargain on price or other terms to remove the processing restriction. The competitive market ultimately will force more efficient outcomes. The market participant exception to the Dormant Commerce Clause says that the same logic applies when the state is a market participant. That is, when the state is basically functioning like a private actor making deals in a market. If a party seeking to do business with the state doesn't like the terms, it can bargain for other terms or find another state or private party offering different terms. The competitive market will work things out. Justice White summarized the basic rule this way. If a state is acting as a market participant rather than as a market regulator, the Dormant Commerce Clause places no limitation on its activities. Justice White went on, however, to qualify and limit the scope of the market participant exception. To determine whether the state is a market participant, the court must first determine what is the relevant market in which the state may or may not be participating. The question of market definition is a familiar concept from antitrust law, but might be a little difficult to grasp if you have not taken antitrust law. Let's say I manufacture beer and you manufacture bottled water. We might sell our products in some of the same retail outlets, and in the broadest sense, we might both be selling in a beverage market. It should be easy to see, however, that beer and bottled water usually are not competing products. If you raise or lower the price of your water, that change is unlikely to affect sales of my beer and vice versa. Imagine instead that you and I both manufacture beer. It is then more likely that if either of us changes our prices up or down, consumers will substitute our products for each other. Even here, the market for beer is likely to be highly segmented into niche markets. If my beer is a watery lager and yours is a fine craft porter, consumers might not switch between them, even with a substantial price difference, because the markets for Budweiser and craft stouts are really different markets. Antitrust economics calls this the cross-price elasticity of demand, and it's one way to help define what comprises a relevant market under antitrust law. One other concept from antitrust law also might help you understand what Justice White did in Wanakee, the concept of a tying arrangement. A tying arrangement is one in which a seller agrees to sell a product or service, the tying product, only on the condition that the buyer also purchase a different product or service, the tied product. At one time, antitrust law condemned tying arrangements as per se unlawful. Under current antitrust law, a tying arrangement is only unlawful if the seller has market power in the tying product market. That is, if the seller is using a monopoly or a near monopoly in the tying product market to coerce the buyer and distort the tied product market. In Wanakee, Justice White said the market for timber is a separate market than the downstream market for timber processing. As a participant in the timber market, Alaska was free to set terms that might discriminate against out-of-state commerce. However, Alaska was not a participant in the timber processing market, so Alaska could not set terms that would discriminate against out-of-state commerce in that market. In a dissent, Justice Rehnquist argued that Justice White's distinction between the upstream timber market and the downstream timber processing market was overly formalistic, and that Alaska should have been able to structure the deal as it saw fit. But another way of looking at Justice White's opinion is in terms of a kind of tying arrangement. Alaska had market power over state-owned timberland. It is unclear how this might have related to the Alaskan timber market in general. That would depend on alternative sources of accessible, quality private supply. In an antitrust case, this would involve many issues of proof and expert testimony. As a back-of-the-envelope calculation, however, we might assume that there were significant advantages for buyers of timber from state lands, which enabled the state to impose a tied local processing requirement that it would not have been able to extract as a bargain-for concession otherwise. Using this analogy to antitrust law, perhaps Justice White's approach had more economic heft than the dissenters suggested. With that detour into the market participant exception, let's come back to the issue of flow control ordinances as taken up in the 2007 case of United Haulers Association v. Oneida Herkimer Solid Waste Management Authority. As Justice Roberts' majority opinion notes, the only meaningful difference between United Haulers and Carbone was that the transfer facilities in United Haulers were owned by a state-created public benefit corporation rather than privately owned. Justice Roberts found this difference constitutionally significant. He noted that disposing of trash has been a traditional government activity for years, and laws that favor the government in such areas, but treat every private business, whether in-state or out-of-state, exactly the same, do not discriminate against interstate commerce for purposes of the Commerce Clause. Further, Justice Roberts stated, the approach of treating public and private entities the same under the Dormant Commerce Clause would lead to unprecedented and unbounded interference by the courts with state and local government. In his dissent, Justice Alito argued that the use of state-created public benefit corporation made no difference at all, and that the failure to treat governments the same as other market actors would lead to the mischief of protectionist legislation. You may notice that Justice Roberts' opinion does not mention the market participant exception. This seems curious. By operating the transfer facility, isn't the local government here acting like a market participant? Justice Alito notes in his dissent, in a portion not excerpted in our casebook, that the respondents disavowed any reliance on the market participant exception. Had the market participant exception been the basis for the defense, Justice Alito suggested, it would have failed, because the local government was both participating in the market and regulating the market in ways that favored the government as a market actor. If the state is simply acting as a market actor and setting terms that discriminate in favor of local commerce, the market participant exception may apply. But if the state is acting as a market regulator and creating legal rules that discriminate against interstate commerce, the market participant exception would not apply. In effect, Justice Alito suggested, the majority applied something like the market participant exception without using that terminology in a circumstance when the local government really was a regulator and not a market actor. Do you think Justice Alito's criticism was correct? Are there other areas in which state and local governments assume responsibility for and regulate state activities that otherwise could be provided by private actors through a competitive market, but that are thought of as traditional government functions? Of course there are. The best example, perhaps, is state and local police forces. Why don't we privatize all policing activity? Let groups of private citizens form municipal corporations or other private associations to fund their own police forces. Those areas with better and more efficiently run police forces will attract more residents and businesses, prompting other areas to compete on price and quality for policing services. On the whole, we should expect the market to provision better quality policing at lower prices than the bloated, inefficient government bureaucracy. Such an idea, of course, is absurd. In economic terms, the negative externalities of disruptive markets in policing could be enormous. We could imagine vast policing deserts, lawless areas left without police forces, no doubt where less affluent people live. We would also rightly worry about public democratic constitutional control over the use of violence and surveillance by private police forces. We might allow private citizens and businesses to access a private market for security guards and equipment, but those markets will not be allowed to compete with regular public police forces. So, was Justice Roberts right to suggest that waste disposal, because of its vital connection to public health and welfare, is a traditional public function that states can control locally without regard to the Dormant Commerce Clause? Or was Justice Alito right that waste disposal should be viewed like any other market under the Dormant Commerce Clause? Finally, the casebook omits a separate dissenting opinion from Justice Thomas. He noted that although he joined the majority in Clarkstown, he no longer believed that Clarkstown was correctly decided, because, in his view, the negative Commerce Clause has no basis in the Constitution and has proved unworkable in practice. What about Justice Thomas's view? Absent congressional action and preemption under the Supremacy Clause, should states be free to regulate in ways that facially discriminate against interstate commerce?